Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Charles H. Packer, who is an attorney with the law firm of Hopkins & Carley in San Jose and Palo Alto. He's actually headquartered in Palo Alto. And I've known Chuck for many years, so that's what I'm going to call him. And he is our community sponsor for this show in Palo Alto for community television in that community. Chuck is the co-chair of the Family Wealth and Tax Planning Department at Hopkins & Carley. He's also a shareholder of the firm and a member of that firm's executive committee. Chuck graduated with his JD or law degree and MBA, it's a combination, from Santa Clara University in 1980 and was admitted to the California State Bar in 1981. The areas of his practice include estate planning, probate, trust, and estate administration, and he also works with family businesses. Chuck also heads the Hopkins & Carley Legal Services for the wine and viticultural industry, a few wine lovers out there. And for the past several years, he has been the chairperson for the Jerry A. Kasner Estate Planning Symposium, which is sponsored by the Santa Clara University School of Law. And he and his wife have 2 children. His wife's name is Joan. And he enjoys cycling in his spare time. And he is a volunteer coach for the Leukemia Society Team in Training activity. And today, Chuck and I will be discussing planning issues related to real estate change of ownership in California. So Chuck, thanks for joining me here.
You're very welcome, Mike. Glad to be here.
Okay. So as we get started, I just wanted to caution our viewers again that this is just an introduction to complex issues to help become aware of them for further discussion with an attorney or other tax advisor who is familiar with them. And this isn't an issue that is discussed regularly in the tax consulting field. Usually we're just going and talking about income tax stuff, but as we're going to see, this estate area of change of ownership for real estate is also a critical one. So Chuck, why should California residents who own real estate be concerned about change of ownership rules when doing income and estate tax planning?
Well, as you will recall, back in the, I guess it was the late 70s now.
I think it's about 75.
75, California enacted what's known as Proposition 13 that set the real property tax levels for people that owned their homes back then at a certain level with a maximum 2% per year, or maybe it's 1% per year increase. So it's not tied to the value of the property, it's tied to their value back then and any additions that they've made to it. For those of us that have bought into established neighborhoods, we're quite astonished to be paying, in some instances, 10 times as much property tax as our neighbors for a somewhat similar, obviously updated home. So the issue is, or the problem is that if we don't watch what we do vis-a-vis gifting the property or adding names of our kids or others to the title of our home, we can trip and trigger a reassessment of an otherwise low property tax rate, property tax value, I should say, and bring it up to today's market value, which could be quite painful for most folks.
Right. So our friend Cronin said, this is the gift that keeps on giving. Every year, you can, instead of paying $2,000 a year, you could pay $18,000 or $20,000 a year.
Right, if you're not careful.
Yes. Depending on the property. So
right.
Anyway, and especially these days with Silicon Valley, with soaring property tax values that we've been seeing recently. This is June of 2016 as we record this. I mean, this is something, again, that we want to be very careful about.
Right. So I mean, there's when you do remodeling on the home, they can reassess to take into account the improvements you've done, and obviously when the home is sold to a new buyer, new owner, it's brought up to fair market value. Now, if the buyer is a family member or somehow otherwise fits into the exceptions for reassessment under the California law, there won't be a reassessment, and that's where you've got to be really careful.
Okay. So we were talking about this increase in tax, that the increase for property tax over a number of years could exceed whatever estate tax or whatever income tax that we're dealing with respect to that property. So again, just to sort of reiterate the importance here.
Yeah, because it comes annually.
Yeah.
Yep.
Right. So why don't you sort of review some of the exceptions for reassessment that apply for families?
Okay. So there is no, it is not a change in ownership to transfer the property or add your spouse's name. Transfer to your spouse or add your spouse's name to the property, or a registered domestic partner. That is excluded from change in ownership. Mm-hmm. There is also an exception for gifts or sales between parent and child, child and parent. Mm-hmm. Okay, but
this is for a principal residence.
Principal residence for that rule, and $1 million of assessed value property. Mm-hmm. So conceivably, an individual could own a commercial property on the Alameda that's assessed at well below $1 million, but its fair market value is well in excess of $1 million now. But we're looking to the value that's on that property tax bill that we get. And as long as that assessed value is under $1 million, that owner could gift or sell that property to a child without any change of ownership occurring.
Right. And
for reassessment purposes. Right.
So, for example, you may have a family. I'm thinking of the extremes. So, my parents bought their home in Saratoga for maybe, I don't know, something around $30,000, and it's probably worth, I'm guessing, about $1.8 million now. Mm-hmm. And so, if they were still living, and they had 10 of these properties that were rental properties that they had owned for 50 years, okay, then, or 60 years, they would have had the opportunity to transfer these to children without having a reassessment in that case. Mm-hmm. Okay. So let's talk a little bit about grandchildren for a moment. And this is a really kind of a tricky one I learned when I was handling my parents' estate. So
there is no such parent-child, child-parent exception from the change in ownership rules for grandchildren unless that grandchild's parents, the children of the property owner, are deceased.
Right, so it has to be both parents. And this is
Yes.
what was kind of a shock to me, is that because my sister had passed away, and my parents, she was the beneficiary for my parents. I thought, well, she's not there, and so her share was going to the grandchildren, but they said, no, Dad is still living.
Right.
And so since he was still living, they didn't qualify for the grandchild exclusion.
Right.
So in that particular case, it wasn't too serious because we sold the house not too long after my parents passed away. Okay. So with these family exclusions in mind, how can distributions from an estate or a trust be structured to avoid reassessment?
Well, first of all, I also want to point out that what we're talking about at this point with these unlimited transfer from parent to child on the primary residence and the $1 million of assessed value, that's for deeded ownership.
Yeah.
If the property is held in a corporation, a limited liability company, a partnership, whole different set of rules apply. We'll talk about those a little later, but this is just on straight type things. So, usually what happens, Mike, is the parents will own their home in Saratoga, that's a substantial part of the estate, or maybe a commercial building, and they'll say in their will or trust that I give this equally to my 3 kids. Okay, no problem at that point, as long as it goes equally to the 3 children. But what happens then is one of the kids says, I don't want to own this property. Another one says, I really want to own this property. And they start doing, some horse trading between them. And at that point, the assessor says, you didn't inherit that property. You inherited a third, but you bought the other 2/3 from your brother and your sister. So we're going to reassess on those 2/3 interests, because it didn't come from mom and dad. Now, there are ways to structure it, but it takes a lot of planning in advance, plus after the parents have died, to make sure that it works right if one kid or 2 kids, but not all kids, want a particular property. You got to be real careful.
So I was dealing with one of these, again, I'm the lucky one, right? This the CPA that gets to, either be the trustee or to help the trustee, in this case my wife, after my mother-in-law and father-in-law passed away. And so we wanted the family residence, we wanted to qualify the family residence to avoid reassessment.
Because you were going to retain it. They were going to retain it.
Because it was, ultimately it was going to go to my daughter.
Okay.
So fortunately, my father-in-law and mother-in-law had some significant investments. So we were able to allocate the investments to my sister-in-law, the house to my wife, who then sold it to my daughter.
Right.
We weren't able to do it for 100%, but we were able to avoid reassessment. I don't remember whether it was 65% or 70%, but it was significant.
Right.
And I said, you guys have received a huge benefit here that you may never appreciate. But
right.
But anyway, so that was one of my little coups. And they asked questions.
Oh, yes.
And they asked for, our distribution schedule and so forth that we put together. And so our attorney helped us out with that. And anyway, so we got it through.
Yeah,
So,
now when you you file deeds, say coming out of a trust, when somebody's passed away, the recorder's office on behalf of the assessor's office wants to see a copy of the trust agreement. Or if there's an entity involved, a partnership or an LLC or something, they want to see those documents too. They want to know who the owners are. They want to know what the terms of the trust are. So like we had a woman gift a piece of residential, it was her residence, to a trust for the benefit of her sons. Now, ultimately, she would have liked it to go to her grandchildren, but the grandchildren cannot be beneficiaries of that trust for so long as the children are alive. Because if they are, then when the assessor's office sees that trust agreement, they will reassess. So we knew where we were going, so we drafted the trust accordingly to not allow it to get to the second generation, actually third generation, so long as any member of G2 was still alive.
Right. And then, though, you have to watch it, because then when G2 does pass away, and let's say it's in a family partnership, then you may have to file change of ownership papers at that point, and that's a whole other different form than what you usually file related to transfers of property.
Right.
So, okay, well, geez, interesting. All right, what about gift tax planning? So are there some exemptions that may apply there? I'm talking about the 5%.
Well, as far as if you're making a gift of the residence
or some other
or
piece of real
property,
estate.
if it's de minimis, 5%, but then you have to look at the cumulative effect. If you can only give somebody those 5% before you get over 51% or whatever it is of the property having been transferred, and then the assessor's office is going to look at it a little more closely and try to see if they can't increase the property taxes.
Okay.
But talk about gift taxes though. Yes, all these transfers during lifetime are subject to the federal gift tax, and at death they're subject to the federal estate tax. So we have to watch out on that too.
Yeah. So there's a lot of different tax regimes that we need to be concerned about when we're doing this planning.
Yes.
So in this case, we're just trying to make people alert for this particular one. So let's talk a little bit about business-related properties again. So we talked a little bit about family partnerships and corporations and so forth. So if the property is held inside one of these entities, do these family exemptions that we talked about, do those things apply?
Nope.
Okay.
Nope.
So
it's only the deeded interest. So you'd actually have to take it out of the particular entity, take it out from under the umbrella, distribute it equally to all of its owners, and that's not a taxable transaction. And then if they wanted to then gift that to their children or something and use their parent-child, they could. But they couldn't just give them the partnership certificate for their interest.
Right. So that may be one way of dealing with the problem, which may or may not work for the family.
Right.
Anyway, so what are the basic rules related to transfers of these business interests?
Well, if the change of ownership or change of control of in this case we're saying a family business, so it could be a partnership, an LLC, a corporation, whatever it is, but it also applies to GM and Google and all, if the change in ownership or change of control exceeds 50%, then at that point the property will be reassessed. So the problem that we've encountered is, in a partnership, if it's a large enough group of people owning a building, let's say, and I don't know what's going on with these other folks' family situations, if 3 or 4 of them have died, and cumulatively that interest is getting up to 50%, upon my death, that may throw the whole thing over, and my kids may get stuck with a higher property tax bill unless the partnership agreement provides that everybody shares it proportionately. So, and then the problem also, as you know, Mike, is that the state of California was a little lax in collecting this data. There was a question buried on the partnership return, income tax return, that asked if there had been a transfer of more than 50% of the interest, and everybody say no. Well, what the question should have been is, has there cumulatively been a transfer of over 50%? Now they finally got that on there, and now failure to respond to that question can trigger some consequences, and failure to report that change in ownership within a timely fashion can lead to penalties and interest and all that. So it's the state's hungry for money, and the local assessors are hungry for money.
Right.
So they're looking for every avenue they can.
So can you use, is there some planning that families can do to avoid reassessment using these entities, like family partnerships?
Yeah, but they're very complex, and it would take a lot of time and a whiteboard here to explain how to do it, drop and swap and all different ways of doing it. But it's a very it's not for the meek or the mild. It takes an amount of planning, and it has to be done right. And if it isn't done right, it's going to come back and bite you.
Yeah. So it's not a do-it-yourself job,
No,
I guess
sir.
is what we're saying. Okay.
No, sir.
Okay. So what should a California real estate owner do if he or she receives a letter from the county assessor's office inquiring about a possible change of ownership?
respond quickly because they have penalty powers
Yeah.
and they can put liens.
Okay. Could maybe you review some of the reporting requirements when you have these situations, particularly like you're terminating, or even after a death in general, and
Right. Well, anytime a deed is sent to the recorder's office here in California, you have to have what we call a P Corp, preliminary change of ownership report, with that deed. It's not public record, but what it does is it says that I am transferring the property to Mike, and the property is located at such and such a parcel number. And then there are a bunch of questions that I have to answer yes or no to allow the assessor's office to determine whether or not that transfer to you is reassessable or is excluded from reassessment. And that form has to be filed, like I say, with every deed. When somebody dies, we also have to file reports with the assessor's office telling them that so-and-so has died owning these pieces of California real property. Now, we may not know what we're doing with them yet. That's going to come later, either because of the terms of the trust or through a probate proceeding, whatever it is. But they have to be put on notice, again, early in the proceedings so that they know about it.
all right. So usually you file a preliminary report and you amend it later.
Yes.
And then we mentioned on the for the partnerships and corporations and so forth, and business entities, in other words, there's a question on the tax return that needs to be responded to. And as I understand it, there's a report that's required 45 days after there's a change of ownership. That's a really short fuse, and
Yes,
an awful lot of people don't
100,
even
yes.
know.
Right, exactly.
So I'm sure they're missed. There are penalties for
Yes.
missing, and so again, we want our viewers to be aware. Okay.
Yeah, I guess the thing that the viewers should remember, if nothing else, is that it's like walking across a pond, and they may not be those may not be rocks you're stepping on. They could be alligators or something else. So you really have to be careful as to how you cross the pond when working with the real estate, because one misstep and you could
be in trouble.
Be
there.
in some trouble. Yeah. Yeah.
Okay. Is anybody monitoring this issue?
They are getting much better at it, as I said earlier, because of the money aspect of it. And as I also said earlier, now when we record deeds where there's entities involved in it, trusts, LLCs, we have to present all the backup documentation to them so that they can review it and make sure that, in fact, the people that we say are the owners of the LLC are in fact the owners of the LLC or the beneficiaries of the trust. And in fact, they're also now taking the position that the filing of a deed will trigger a documentary transfer tax, which in San Jose is $4.40 per $1,000 of value. And in other parts of the county, it's $1.10 per $1,000 of value transferred. So they are taking the position that you owe it unless you can show me why you don't own it.
Right.
So they are monitoring it. They're
Yeah.
paying more attention to it, and that was something we never had before.
Right. So I think what's going on is basically we can say that the county assessor's office is working very closely with the county recorder's office.
Yes.
And so anything that happens where there's a deed that's recorded is going to trigger some sort of an inquiry if other paperwork hasn't been submitted.
Right. The recorder takes it and immediately sends it to the assessor's office before you get the original back. So it's there's a process in place.
Yeah. So it's happening. Now, the people are doing quitclaim deeds and other things, I think, unrecorded quitclaim deeds, but I think they're really asking for trouble when they do that sort of stuff. Not only that, but of course, then they can do retroactive assessments
Right.
with penalties and interest.
Right, because it's not the recording date in California, it's the date the deed is signed. So recording is only to put third parties on notice. It's actually the date the deed is signed and delivered, and you decide to hold it and not record it. If you recorded it 10 years later, they can come back and say, Michael, you got this back in 2016. And so we're going to start taxing you accordingly.
Okay.
The fact that you just didn't record it until 2026 isn't our problem.
Okay. Got about a minute left. Do you have a final thought that you want to throw out there, or maybe we were talking about the gift tax issue?
Well,
Maybe
yeah,
should
you
throw that
know,
out.
something that we've seen for years is self-help estate planning. So somebody will say, well, I'm going to put my oldest son on the deed with me so that we don't have to go through probate. So he doesn't have to go through probate when I die, and I know he'll take care of his younger siblings. Well, that's a taxable gift now by putting you on that deed, and the IRS is monitoring those with the state controllers, State Board of Equalization, and there's no assurance that you're going to actually do what mom wanted you to do later. And when you do take care of your brothers and sisters, that's a gift from you to them. So in an attempt to avoid paying legal fees up front, they can end up paying a whole lot more at the back end than they need to.
Okay.
So
I hope that our viewers can get a little appreciation that this is expensive stuff. If you make a mistake, and so this is an area that it really pays to get some good legal and tax advice. And not everybody is real up to snuff on this. These are complex rules, but they're apart from the income tax rules. It's not part of the normal education that people get
right.
for their degrees and so forth. So folks, we're out of time. Hope to see you next time on Financial Insider Weekly.